Hello everyone, good morning and welcome to our book launch today. Our event today is the book launch of Thai Criminal Law, authored by Assistant Professor Dr. Rณกร Bunmi, Faculty of Law, ธรรมศาสตร์ University. We are very delighted to have our guest today. First, before we begin, I would like to introduce our honorable guest today. Begin with the first one. We have Professor Dr. คณพล จันหอม Professor of Law from จุฬาลงกรณ์ University. Welcome อาจารย์คณพลค่ะ Secondly, we have Professor Chan Bing Chong from Singapore Management University, who is not here yet, but he will join us soon. Thirdly, we have Associate Professor Dr. ปกป้อง ศรีสนิท Dean of Faculty of Law. Welcome อาจารย์ปกป้องค่ะ Up next, we have Assistant Professor Dr. Lester Chu, Assistant Professor of Law from ธรรมศาสตร์ University. Welcome อาจารย์ Lester ค่ะ Up next, we have คุณสุรัสวดี เจียมสุวรรณ Senior Litigator at Tiligi and Gibbon International. Please welcome คุณสุรัสวดีค่ะ I'm really delighted to introduce you, our audience, to our author today, Assistant Professor Dr. รณกร บุญมีค่ะ Last but not least, you will be having me, Assistant Professor Dr. Yada Detchai Chirpasit, as your moderator today. If you're ready, I would like to ask our Dean for our opening remark for today.
Oh, thank you, Ajarya. Good morning. I am very pleased to welcome you all to the special event, the book launch of Assistant Professor Dr. รณกร บุญมี the latest work on Thai criminal law. Dr. รณกร is a brilliant faculty member known for his insightful legal research as well as his administrative work as a vice rector of the university. This new book is said to be a fantastic resource for both legal professionals and students, offering a detailed and up-to-date look at the complexities of Thai criminal law. I think this is the first Thai criminal law written in English. The release of this book showcases Dr. รณกร commitment to academic excellence. It's also a significant achievement for our Faculty of Law, strengthening our reputation as a leading institution for legal education and research in Thailand. Let's congratulate Dr. รณกร บุญมี on this remarkable achievement. I hope that we have a fruitful discussion on this event. Thank you.
Thank you, Dean ปกป้องค่ะ I forgot to mention that this is the book that we are launching today, and it is published by LexisNexis, available both as hard copy and online. And I think that our admin probably put the link how to purchase this. Up next, I would like to give the floor to our author for today, Assistant Professor Dr. รณกร ค่ะ
Thank you so much. Thank you all for being here. I was honored to have you all sharing these moments with me. Let me take you to a journey. This book started its life almost 10 years ago when I was assigned to teach criminal law at the Bachelor of Law degree taught entirely in English. It was the first kind of its program launched at ธรรมศาสตร์ University. While I was preparing for the materials for the class, I realized that there was a big gap. Sorry, I should share with you. Right. Lack the English resources, the materials that students can rely on. I don't know how to teach a class when students do not have materials. They cannot understand the contents, the lessons, the discussion fully and confidently engage in the discussion. So I decided at that moment, almost 10 years ago, that I have to produce a comprehensive resource for my students. That is when it started. But the journey is not so straightforward. 4 years ago, I finished my first manuscript. You may ask if I finished the first manuscript 4 years ago, why I just launched the book today. It's because I kind of reluctant at that moment. Initially, I intended for it to be published by a local publisher, but I saw its potential. I hope it reached a wider international audience. Therefore, I proposed the book to LexisNexis. Shortly after that, I was invited to join another exciting project, the newly promulgated Lao Penal Code, which has no text or books to discuss. So I engaged in that project to produce actually a textbook that not only explained the Lao Penal Code, but compared it with the Thai, French, and Singapore Penal Code as well. Being part of that project changed my mind. I saw a big room, a very potential room for my books to be improved. So I made a bold decision. I started anew. I scratched that first manuscript, 150 pages, put it into the trash bin, and I start writing anew. A new book that you have in your hands today, almost 500 pages, consisting of 16 chapters. The first two chapters, the initial draft is 150, and then I rewrote the draft, expanding it to 500 pages, 16 chapters. The first two chapters talking about the historical and foundational background of the Thai criminal law. Tracing its evolution from the pre-modern era to the present day. These two chapters provide essential context for understanding how contemporary Thai criminal law has been shaped and applied. From chapter 3 to 11, I discuss the basic principle, the general principle of Thai criminal law, ranging from acts, omissions, intentions, causation, so on and so forth, justification, excuses, participation, everything that you need in order to understand the foundation of Thai criminal law. Chapter 12 to chapter 16, I discuss the primary offenses of Thai criminal law: homicide, assault, sexual offenses, and offenses against property. The book takes the reader on a journey from understanding foundational principles to observing how they apply in real-life cases. And as you will see in the book, that I discuss the principle, not just the underlying principle behind the provisions, but I also give example from the Supreme Court decision as well. Let me give you an example of that. When I discuss the causation to conceal the cause of death, except for example, when the defendant assault injured a person, right? This is from the book, page 96 to 97. When a defendant assaulted the victim, and he mistakenly thought that the victim was dead, but actually the victim was just unconscious. So what did he do? We have many kind of these cases. The defendant just concealed the cause of death by burning the victim, by dumping the victim in the body of water, right? In order to conceal the reason why the victim was dead. But actually, that is exactly why the victim was dead. In the case like this, how should we approach? How should we interpret? How should we apply the law to the cases? right? So I offer two approaches. First, we can think of this case as two scenarios. First, you assaulted, right? And then you negligently murder a person. So that would be 295, 2 years in jail, and then 291, maximum 10 years in jail. That was the approach some Supreme Court judges took. And I also analyzed another type of Supreme Court judgments, and I find that there are a better approach. They don't think of these scenarios as two separate scenarios. They think of them as one single linear scenario, that when you assaulted someone and end up causing death, that should be 290, assault causing death, which produced 15 years in jail as a punishment, right? So I don't say in the book, I don't make a judgment, I just a scholar. So I tell my leaders there are two ways to approach cases like this. I give them tools to analyze, and I offer my insight. I don't just explain the law. And then give the Supreme Court decision. I compare them when they're conflicting with each other as well. And that, I think, should be a unique feature for my book, not only for my students to understand, but for practitioners as well. Also, when we look at the proportionate force, that is a required element in Section 68, when we talk about self-defense, right? I said, okay, it's quite straightforward that you can kill a person in order to protect yourself from being killed. That's basic, right? We can say that. However, if you take a closer look at the Supreme Court judgments, because the penal law, that the Thai Penal Code does not say much about this, right? We have to look further. We have to find the answer from Supreme Court decisions. When we look at the power of Supreme Court decision, we can come to the conclusion that the Supreme Court does not only allow people to use fatal force against a fatal force or lethal force, but you can use fatal force in order to protect you from being raped as well, right? But where does that end? You can use lethal force to protect you from being raped, but the Supreme Court does not allow you to use fatal force to protect you from being sexually harassed or sexually assaulted. So being raped, you can kill. Being sexually assaulted, you cannot. I don't make the judgment. I ask if that is reasonable. I trace back on the Supreme Court, and then I highlight the Supreme Court that confirm my hypothesis. So in this case, on page 137, it is the Supreme Court allow the defendant to use, the female defendant, to use fatal force in order to protect herself. But in the case in page 138 and 39, the Supreme Court say outright, if it is just a sexual harassment or sexual assault cases, you cannot use fatal force. After I compare Supreme Court decision, lots and lots of them, I also keep insight. I also criticize, that is something I think unique at Thammasat, in my book as well. I also criticize respectfully, of course, the Supreme Court, and I say in some sexual assault cases, it kind of getting close to rape. Lay people cannot differentiate between being sexually assaulted and being raped. And they should be allowed, to some extent, to use not fatal force maybe, but a more serious amount of force to protect themselves, and therefore to sentence a woman to 5-year imprisonment in the case 2001/2530, in order to punish a woman who is being sexually assaulted in a forest alone for 5 years. I think that is something we should talk about. So in the book, I don't just explain the law. I discuss, I give my insightful comments, and I provoke them to think further. That is something. It's as if I talk to them by myself, my professor. Sorry. Also in the books, I drew from my experience studying in the UK and Singapore. One of my professors just came in from Singapore, right? So I drew from my experience. So I compare occasionally. This is not a comparative textbook. This is a normal Thai criminal law textbook that we use to understand the Thai law. But from time to time, occasionally, I compare Thai law with the UK and Singapore law and less frequently with French and German law as well, in order to make my students, the leaders, understand how Thai law can be compared with other laws in other jurisdictions, and at the same time allow foreigners who don't understand Thai law to see that Thai law is some kind fascinating and may use Thai law in the future to be the subject of their comparative study. So I try to open the window to wider international audience. Included in the books, at the end of the book, I include translation of some 120 sections. Those are the key sections for you to understand the Thai penal code, the Thai criminal law. Admittedly, there are more than, my colleagues say, oh, actually there are more than 400 sections in the penal code. I know, but this is the first edition. In the second or in the future edition, right, I may take the challenge to translate every section of them. But I think these 120 sections are proved to be useful for those who cannot understand or who cannot read Thai language. So they can understand the basic, not just the basic, but the essential information to understand what the Thai criminal law is. I'd like to take this moment to express my gratitude to Faculty of Law, not just to the Dean, but to the faculty to graciously, financially support me through the journey. I'd like to speak out loud to these three particular persons, Dr. Surasak Likasit Watanakun, Dr. Tuwikiat Minakanit, and Dr. Surasak Pokpong Sisanit. They are not just my professor, but they are the people who instill the belief, the obsession, not just the belief, the obsession of criminal law in me. They make me realize that criminal law is not just the tool for the government to control, to regulate our behavior. They are something that worth make you deep understanding about. That's something that you should dive into in order to understand the law, not just the law, but your life as well. So I'm fascinated by the criminal law, by these three particular people. And I also like to take this moment to thank my international mentor, Peter Ramsey from LSE and Andrew Semester from NUS, who were my supervisor at the master and doctoral degree. They make me realize that criminal law is not just a doctrinal discipline, right? They are something that you should think about in terms of philosophy as well. So you see, in the first two chapters, I don't just talk about the history, I talk about the philosophical foundation of criminal law. They made me realize those things. And of course, I like to thank Professor Chan Win Chong, who here with us today, and Professor Stanley Yo, who took me through the journey to the comparative study with other jurisdiction, and that made me a better scholar. And I add some comparative perspective in the book as well. Last but not least, I'd like to thank my wonderful and beautiful wife. Today is our 12th wedding anniversary, and my two beautiful daughters. Their patience, their encouragement, and their support has been the center of my journey of this book. Without them, I don't think I can complete this. This is that book as it is mine. Thank you so much, especially for your smiles. My hope for this book is, of course, the primary purpose of this book is for it to be the tool for our student, not just at Thammasat University, but for students, Thai students who like to understand criminal law in English. It proved to be, I hope it proved to be a practical and reliable references for legal practitioners. And it is, I hope it should be a bridge between Thai scholar and international scholar. I hope for it to spark curiosity, inspire dialogues, and contribute to the evolution of Thai criminal law. May it shed the light for the younger generation of students, of lawyers, as my predecessor shed the light for me in the past. Thank you so much, everyone, for being here to share this moment with me.
Thank you very much อาจารย์รณกรนะคะ so it has been a long journey so big congratulations again and again for those who have joined us this book Thai Criminal Law published by LexisNexis both available as hard copy like this one and also ebook so I think this should be a delight time so I would like to give the floor to my honorable guest today so first up I would like to ask Associate Doctor, sorry, our dean to take the floor, please.
Thank you very much, Ajahn Krab. First of all, I would like to congratulations again to Ajahn Ranakorn. We have discussed many times in criminal law and criminal procedures. He is one of the brilliant faculty member in the Faculty of Law. So today I would like to have a personal comment on the excellent book of Thai criminal law of Ajahn Ranakorn Bunmi. I would like to distinguish into the form and the content of the books. In terms of the form of the books, I really appreciate the form of the books because Ajahn Ranakorn have the paragraph number in each paragraph. It's very rare in Thailand. I think not many writers, legal writers in Thailand have add the number, the paragraph number in each single paragraph. I think it's very useful for the reader to understand the context and the content of the book, and also for the writer as well in the new edition and the second edition, because the new edition the pages has been moved, but the paragraphs is still the same, and that's the first appreciation of the book of Ajahn Ranakorn in terms of form. In terms of content of the book, Ajahn Ranakorn has written all of the Thai criminal law in the one book. That's very appreciated and very nice, because in Thailand we have separate the general principle in one subject, and another is a specific offenses in another subject. So many books in Thailand, in Thai, we have general principle, one book, and separately the special and the specific offenses. But the Thai criminal law of Ajahn Ranakorn Bunmi, he include all of that in the one book. It's very insightful and it's very useful for those who would like to study Thai criminal law in one book. I think it is the style of the common law books, right? Yeah, but not for the European country. European country, they separate the general principle and the specific offense, like happened in Thailand. Next, for the contents of the book of Ajahn Ranakorn, I also appreciate the style of the writing of the books, because when Ajahn Ranakorn refers to the Thai Supreme Court, he refers to the Thai Supreme Court and analyze the content in the context of Thai Supreme Court without copy the judgment. So that I think that is very good style to write the book, because the big volume of the book is not from the content of the Supreme Court. It's from the analysis of the Thai Supreme Court, and write down and comment and just refer to the number and the year of Thai Supreme Court. So for the conclusion of the books, all of the big volume of the books is come from the real context and the real analysis of the Thai criminal law that Ajahn Ranakorn has been done. So that's all my reflex to the books of Ajahn Ranakorn, and I would like to say again, congratulations, and you have done a very good job and excellent job. Thank you so much.
ค่ะ thank you ดินปกป้องค่ะ so up next I'm delighted to ask Professor Dr. คณพลจันหอม from Faculty of Law จุฬาลงกรณ์ to take the floor please.
Thank you very much for inviting me to the very important criminal book launch today. Congratulations again for Dr. Ranakorn's contributions on criminal law, especially for Thai people. For Thai criminal law, this book is a very significant contribution to the field of legal studies. This comprehensive text offers a detailed and insightful exploration of Thailand's complex criminal law system. I would like to talk about the 4 key strengths of the book. The first one is I agree with Dr. Pokpong. It is clear and concise writing style. Dr. Ranakorn's writing style is both engaging and informative, making complex legal concepts accessible to a wide audience. This clarity is particularly important for those unfamiliar with Thai law. The second point is the in-depth analysis. Like Dr. Pokpong says again, the book delves deep into the intricacies of Thai criminal law, providing thorough examinations of general principles and specific offenses. Third, the real-world applications. Dr. Ranakorn effectively bridges the gap between theory and practice by incorporating numerous real-world case studies. These examples helped to illustrate how legal principles are applied in actual court cases. Last but not least, the up-to-date coverage. The book remains relevant by incorporating recent legal developments and reforms. This ensures that the readers have access to the most current information. However, there are some areas of improvement. The first one is the deeper dive into criminal measures part. While the book provides theoretical frameworks of the criminal measures, especially the theories of punishment, a more in-depth explorations of criminal measures could be beneficial. This could include discussions on punishment, security measures, and other types of criminal measures. Second, the book can be put more important offenses both within and out of the criminal code. For example, arson, kidnapping, defamation, corruption, or the narcotic drugs law. Third one is the practical applications and case studies. While the book includes some real-world case studies, a more intensive collections of practical examples could further enhance its value. For our assessment, the Thai criminal law by Dr. Rณกรis a valuable resource for law students, legal practitioners, and anyone interested in understanding the nuance of Thai law. It provides a solid foundation for further study and research. For the recommendation for this book, I highly recommend the Thai criminal law book to anyone seeking a comprehensive and authoritative guide to Thailand's criminal justice system. It is essential tool for both academic and practical purpose. Again, thank you so much for inviting me here today, and congratulations for your accomplishment.
ค่ะ thank you อาจารย์คณพลค่ะ so far we have heard like two perspectives from the academic. So I think that up next we will be delighted to have Kun Suraswati to please share with us the practitioner perspective of this book, please.
First of all, congratulations, Dr. Rณกร. Thank you for inviting me to this esteemed panel. I must clarify that I do not view myself as an academic, but rather as a legal practitioner who understands how things work in the courtroom. As a former judge, now an attorney, I have decided on numerous criminal cases and also defended for many in a criminal court. My views stem from this perspective, and I hope the viewers today understand that I will be brutally honest because I truly trust that the author is open-minded to a true critique of his book. My goal is to elevate the book to meet users' expectations. My comments aim for positive changes and should be received in that spirit. Now, let's delve into the details of the book. First of all, the title. The book has a very short title, Thai Criminal Law, which is, for me, is a very broad term, making it difficult to identify the target market for the book. Given its length of 400 some pages plus the translation of the penal code, it definitely cannot cover the entirety of criminal law in Thailand. The title could be more specific to help navigate this expectation of a reader better. The acknowledgement part of the book by the author attempts to address this, but provides very limited help. It says that this book is also for the general population, anyone interested. For me, it provides some useful insights into Thai criminal law, which could help me with communicating with English-speaking clients. I truly doubt that the book effectively explains Thai criminal law to lay persons or foreign lawyers in a pace and order that is easily followed or explained well enough for them to understand the workings of Thai criminal law in practice. The size of the book is already telling of this. Perhaps a better title should be Thai Criminal Law, Principles and Essential Offenses, or Bun Mi's Guide to Criminal Law. Well, I'm not the best at naming books, but these are just some ideas that popped up while reading the book. The book does not try to differentiate Thai criminal law from other countries explicitly for me, but it does reference foreign legal sources and highlight similarities and differences to a certain extent. While I do like this approach, because the book is designed to focus on Thai law, it would be interesting to have a Thai criminal law book that could base itself on Thai original references or does not base itself mostly on foreign textbooks and articles from other countries, at least for the first part on principles. Perhaps the book is reflecting an important fact that there is limited availability of Thai sources, Thai legal text sources, and that it is easier to access English common law or other jurisdictions' book. Also, while reading, one may ask, is it misleading to reference foreign law books here? Is it saying that we are the same as other jurisdictions, or is it not? The title might give buyers the impression that the book covers more than just an introduction, but the entirety of Thai criminal law, potentially leading them to believe it encompasses all aspects of Thai criminal law. But this book does not cover all aspects of Thai criminal law, cannot, the size of it. Offenses, details starts from page 265, indicating the limited first 260 pages coverage on criminal law principles. Compared to other Thai criminal law books written in Thai, which comes in series, and this was mentioned by Professor Pokpong, Dr. Pokpong, you can see that the size of this book is surprisingly thin for the job. For the offenses, the book mainly discusses petty offenses and 5 categories of other offenses, leaving the rest in the code and other acts untouched. The book briefly mentions other sources of criminal law, such as other legislations than the code, but does not include detailed information about them. Who is this book for? In my opinion, after my first brief flip through the content of this book, I think it would be ideal for 1, an LLB bilingual program student in Thailand, 2, someone from Thailand planning to study criminal law in an English program abroad, or 3, someone who cannot read Thai but is eager to learn the principles of Thai criminal law. This book would definitely help those planning to study abroad in preparing linguistically for what lies ahead in their studies. I did not reach another conclusion after having read the book. In my humble opinion, this book is for readers with some knowledge of Thai criminal law or criminal law in general. Due to the concise nature of the book, parts of the context quickly jump to new topics, which may confuse beginners or laypersons. While Chapter 1 is meant to introduce what is criminal law in Thailand, where can you find it, and what is the history of it, the name of the chapter is Context, History, and Sources. In the introduction, I expected to see a discussion on Thailand being a civil law jurisdiction and its impact on our approach to criminal law. I'm curious about how references to sources from other countries influence our interpretation and the actual practice in Thailand. Perhaps this could be added to the history part of the chapter. As comparison, most references provided in the earlier chapters of the book are made to reference foreigners' book or resources, and later chapters on offenses, the references are mostly, if not entirely, based on the Thailand Supreme Court judgments and Thai criminal textbooks. There are 2 questions here. 1, regarding the principle of Thai criminal law, is there any other civil law jurisdiction which supports our way of things, or any source from Thailand or on the matter enough to support this explanation of the principles in this Thai criminal law book? Say Chapter 3 on Act only refers to 1 Supreme Court judgment, and that one did not explain an act directly. The second question is, what does the Supreme Court judgment role here in Thailand? The second part was explained briefly in Chapter 1, paragraph 150, that these judgments are not binding, but perhaps more can be discussed here. I think that's important. I believe people from other jurisdictions would be eager to know this and want to understand the working of things here more thoroughly, in which I trust that the author is more than capable of doing it. clarity request. From the content, page 7, the author skipped from introduction of criminal law straight into administrative fines and contempt of court as subsections. The author only explained in tiny prints inside the book below that these fines are not part of Thai criminal law. But this type of subheading in the table of content can be misleading to newbies. I would prefer that these two issues in a subtopic that clearly categorizes that these are not criminal law. The author should mention the recent changes in criminal offenses in relation to fines, changing criminal fines to penal fines, or the role of the Supreme Court in decriminalizing offenses, which this decriminalization of many offenses would aid businesses in Thailand. This legislation is significant and not yet widely known among lawyers, and this probably can be added in Chapter 1. Other legislations. The name of the legislation can also be mentioned where the author intends to differentiate criminal law from civil fines. So more details can be added there. As a practitioner, how the chapters and subheadings are arranged is very important, because when we actually put these books to use, we start there and wish that each chapter is those table of content is self-explanatory to a certain extent. If not, should include clear guides into the text of where the next or where the answer would be. Categorizing offenses in this chapter is helpful, especially the public offenses and compoundable offenses. This issue is regularly asked by clients. They're at all by this. So there should be a word of caution somewhere in the beginning that this is not the entirety of criminal law and the workings of, or include Thai procedure law. It should be noted from the beginning that those mentioned in the criminal code or other legislation interrelates with other procedure laws as well. The term, for instance, the term complaint in this book means reporting to the authorities. It does not mean the plaint or complaint being submitted to the court. So there's a word of caution for beginners. This term is again used in Chapter 2 on statute of limitation. So again, this is probably why I think the book is not designed to read by lay people. The next chapter on application of criminal law. As a practitioner, I have always wished that academic books like this would have more practicality in the character. While this book shows clearly how Thammasat graduates like myself are carved, are made by our professors, reading this book really brings back those days to life, but in a different language. This is how Thammasat graduates are able to understand the law from its roots. By understanding the principles, we don't get lost easily when reading Supreme Court judgments. And I thank Thammasat University for planting that legal mind for all of us. Example, I wanted to see more explanation on adjudicative jurisdiction, of how it interplays with actual cases. Say if the case falls within one paragraph of a section of law, whether we do need to explore other paragraphs or not. And this can definitely be added to the introduction of Chapter 2. Chapter 3, speaking about referring to another chapter. In Chapter 3, which meant to explain X as an external element, this chapter mentioned words involving a mental element as well. But later in the book, there is more than one mental element, say a mental element of an offense. So there are choices of words here, and I guess more explanation is required to differentiate these wordings for your readers. Again, where the book explains basic principles, like in this chapter, basic explanation on various foreign sources, and referred to two main Thai criminal law books. No Supreme Court judgments were discussed on the issue of act. Only provided a short discussion on how the court in few cases did not discuss the issue of omission. What I would like to see more is discussions among Thai lawyers in Thailand on the code of law and the Supreme Court judgments, whether there is any providing definition to these wordings and how it is really discussed here in the community. I believe Supreme Court judgments should be subject to more critique, and I like that about this book. Firstly, more judgments should be made available to the public rather than just being a selected few highlighted ones. Secondly, there should be more academic forums and books dedicated to discussing these judgments, like as this one. This would not only enhance the already high quality of the court's decision, but also provide the public with a better understanding of the laws. Additionally, it will serve well to have the public review of the authorities' work and foster a society that values constructive criticism. Perhaps we will see more Supreme Court judgments explaining on principles of law after that, giving us more examples to play with in a book like this. To the chapter that I love is chapter 4, causation, which Dr. Rณกรalready raised that in his introduction. When it comes to this one, I'm very glad the flow of the introduction into the content of this chapter is the best of all 16 chapters. The discussion in the book centers itself on this one with Thai sources, books, and Supreme Court judgments. I felt like, okay, he's at home here. And this chapter also comes with a nice conclusion, which assures that the readers are not lost. Chapter 6 to 11, I think the author excels in referring to Thai resources. The headings of the table of content has better flow and detail. One note, though, there is one surprising heading in the form of a question, like, why is it not always right to punish a wrong? While I like the idea, probably it doesn't really go well with other headings. On chapter 11, in a practitioner view, mitigating circumstances is that the name of that chapter. To a practitioner, it sounds like something to discuss before, after, or around chapter 6 to 8, which is about the defense and whatnot. When it's in chapter 11, I think it's a bit too far away. Or perhaps there is a way to make that connection for the readers from the beginning. Chapters on offenses are well references to Thai sources and gives a quick run-through, citing well-known cases, really bring back memories among Thai law practitioners, again, well-written. Last comments to the author would be, perhaps set yourself back a little, slow down, and try to make sure that your targeted market follows your words. The book shows that the author understands the law very well, but does his book work for him efficiently in explaining the law to his followers? Give more time and effort in the introduction part, your table of content, and especially the acknowledgement part. The buyer will see whether the book is for them or not and see clearly what to expect from this book. Indeed, 500 pages for this author's knowledge on Thai criminal law is not enough. Thank you.
Thank you, Khun Surasawadi, for kindly sharing with us perspective from practitioner. So up next, I guess we'll be switching back to the academia. So we have here with us an instructor from LLB program. So I would like to give the floor to Assistant Professor Dr. Lasashut, please.
Thank you very much, Ajahn Yada, and also thank you for inviting me today. I'm very happy to be here. Congratulations, Ajahn Rณกรณ, on this great achievement. I'm very, very happy to hold this book physically in my hands. Also, thank you for the copy. That was very kind of you. Now, I was almost prepared to just also focus on all the positive parts, but now the floor has been open to also be a bit more critical, so I may mix it. I may mix it in a bit. No, but just joking. So first of all, as you know, we teaching in the LLB program, we need materials, we need proper resources for our students, and finally now in criminal law, we have really a very proper resource. I think there have actually been 2 books published in English. One is a translation and another one on Thai criminal law in English already, but I would say this is now the first real work that really reaches another level also for our students to have proper materials. I think that is really a big achievement. You mentioned our program is now running for 10 years, and we have published several books in English now, and now we have really a very great criminal law source as well. Now, for our listeners and also for everyone here, I'm actually teaching also 2 criminal law related subjects in the LLB program, which is one business crime and the other one international criminal law, actually with Ajahn Bokapong and Ajahn Rณกรณtogether. So for that, also for these subjects, having a firm ground and a firm basis in Thai criminal law, also now supported with these English materials, will be very, very helpful. So yeah, congratulations again on that. That's really a very important achievement. And that, of course, in the 2nd, 3rd, 4th, 5th edition will always become a greater achievement, so we can look forward to the future. You have basically now monopolized that position here to have a proper Thai criminal law resource for the future in English for our LLB students. I think that's really great. Now, regarding the book itself, I really enjoyed reading it, I must say. So I think you have a very good English writing style that is short sentences, easy to understand, also engaging. Now, take this case, take that case. So it has this kind of, as if you were speaking to us here. I really enjoyed that. So it's not written in a too technical language that would be difficult to grasp. So I do also share the thought that this is not for lay people, most likely, but it is really for students who are wanting or having to look deeper into this subject. And for them, it will, however, make it approachable by having a language that is not too difficult or too technical. So I think that is really very engaging. Now, also, I was very, very happy about your translation of the selected provisions at the end. I think many of our students, but sometimes also other foreigners, if they type into Google Thai criminal code, they will go to Samui for sale. Samui for sale. I don't know why that website has this code on it, but Samui for sale has the source. And I always wondered, that can't be true. Yeah, that can't be really the best source that we use. And also the translation is, language-wise, very bad. So now your translation is, of course, excellent. And it's really nice to have particularly basically the general part in its entirety, I think, right? Because that is, of course, what we use in our education in terms of the application of the criminal law so frequently also with offenses that are not in the penal code. So these provisions are really foundational. So having them all now in proper and precise English, using the right terms here, I think that is already excellent. Also, in terms of the form of the book, the very detailed index, very helpful. I know that it is always taking a lot of time to create such an index, but once you've done it, it is really something that is very, very helpful if you just want to find something very quickly. So also that, excellent. Now, apart from that, I think also when I read through the book, I was also quite impressed by the way how you approach Supreme Court decisions. And that is really by discussing them and not only reproducing them, by trying to perhaps also grasp what the Supreme Court might have thought or meant, which is sometimes difficult perhaps, because the decisions may sometimes be quite short and maybe the reasons are also quite brief. So you're then opening up these decisions for further discussion, basically, and say, well, this could be seen this way, could be seen that way. I think I remember in one case about, I think, larceny, you even say, well, this is perhaps not a case that should be treated as a precedent. I think it was something about theft of, I'm not quite sure what it was. Right, immovable property, exactly. And there you basically even say, well, be careful with this decision. This can't be really counted as a precedent. So I think that is exactly what students also need, this guidance, right? So I think that is also very helpful. Then I would also really commend you on your detailed discussion of the general part. I also enjoyed the causation chapter quite a lot. So I think that is really a very detailed chapter with many case studies or many little boxes where you have so many examples in it that because causation particularly is not easy to understand. And therefore having these kind of illustrations here is of course also very, very helpful. Now, I also remarked your critical remarks on the very scattered offenses in many, many other acts outside of the criminal code. And that is, I think, really something that I also, so I teach business crime where we have laws all over the place, of course. There are basically in almost every act of parliament, there is at the very end a tort, a penalty chapter. And you can imagine these are hundreds or even thousands of acts where you have provision. So having this current approach, apparently, that the Thai legislator rarely adds anything in the penal code, but always puts something in specific legislation is, of course, for the workability of criminal law, not very helpful. Now, I would even argue, so last week I taught in my final business, or 2 weeks ago in my final business crime class, I talked a bit about environmental crime. And I asked the students, okay, do you find any environmental crime offenses in the penal code? And okay, you may classify some as having some impact on the environment, but actually I would there even say, well, isn't that something that deserves a bit more prominence, where maybe you can move a bit of these offenses into the core criminal law? Because I think many of us agree that the environment and the protection of it is something that is quite, we may say nowadays, at the core of what we should be aware of in terms of preventing harm. So I think also that I took that as a very good note, even though you are, I think, not too critical, but I think you have a very diplomatic approach here throughout the whole book, which is of course very useful also for your future career. But I would have been sometimes a bit more, I think, a bit more punchy even, yeah. But I think it's the right tone throughout the whole book. Now, I would agree also that I was looking for your mentioning of the penal offenses, and that is not yet included, I think. But I think that is really a major decriminalization where that is indeed limiting the scope of criminal law quite significantly. I mean, many offenses are just taken out of criminal law, basically, into this new category. I think that is just in the first chapter to discuss recent trends, developments. I think this decriminalization trend is really quite something that could be mentioned there. Now, moving on, I also, of course, enjoyed your comparisons with other legal systems. I do agree. Also, you mentioned that yourself, due to your own legal education, you have quite a lot of insight into English and Singaporean law. That is, for me, of course, very interesting to see these comparisons. And you also sometimes then refer to German law, French law, and to the European Court of Human Rights, which, of course, also has very interesting things to say about many of these issues that you cover in your book. So I enjoyed that very much. I would agree that perhaps sometimes you might perhaps then think about mentioning to what extent these approaches would be introduced into Thai law and would fit, or whether there are any problems by, I don't know, using German or French law or English or Singaporean law in certain types of cases in Thai law, or whether it is basically generally feasible to use that. So I think it is a very nice, opening the window to also other jurisdictions and having this kind of really broad view. Yeah, but you may sometimes then even consider again, perhaps moving out of your diplomatic role and maybe saying clearly, well, I believe this is a solution that we should also consider adopting, for example. Yeah, so then having perhaps even a bit more opinion in it, maybe. Now, I'm used, of course, also to German textbooks about criminal law, which are often very opinionated, and they clearly say, this is good, this is bad, we should do it like this. Of course, laying out all the different solutions, but then having a standpoint, and I think this is the way we should pursue, for example, after discussing all the different approaches. And of course, there are different ways to write books. I think it is already having all the material for discussion is there on the issues. Now, I also find it interesting that if I read it from the perspective of someone who is trained in German criminal law, but who has now, of course, moved into studying Thai criminal law as well, to see that there are actually many similar issues basically globally. So, for example, I think in the chapter that compares fraud and larceny, I think you have these cases about people somehow getting petrol at the petrol station but not paying for it. Is that larceny? Is that fraud? We have the same in German law as well, and students are tortured with these types of cases for many years. So it's interesting that actually Thai students have to go through the same torture. Also, for example, these cases about that you also had on your slide before, conceal the cause of death, and then these issues of causation. We have exactly similar cases also. I remember back in the German case, or for example, what I found quite interesting that you just mentioned in your presentation about the proportionality in self-defense, where also again from the German perspective, there's a long discussion because the German self-defense provision does not have an explicit proportionality requirement. So basically, you can kill to protect property. That's fine. There is no proportionality evaluation there, which sounds very brutal, of course. And so also in the German criminal discussion, there is then the question, well, should there be some limitations? And then something has been invented that it should not be a grossly disproportionate relation. So if a person steals some apples and then you shouldn't shoot the person from your apple tree or something. That has been considered to be too extreme, but otherwise life, property, these are not categories that would be evaluated against each other. There is no proportionality requirement. So also there, I found that quite interesting when you mentioned lethal force in case of rape, okay. If it's only sexual assault, then not okay. Interesting discussion, whether self-defense allows these proportionality assessments or not. So therefore, I think overall, I'm very, very, I feel now much more educated in Thai criminal law after reading it. Now, one point that I would just like perhaps to make that you could consider at least mentioning at some point is how Thai criminal law applies to legal persons. I think so far you focused on the application to natural persons only, which is, of course, I think also pretty much the core of our legal education. Now, I cover in business crime, based on our course, I cover the corporate crime as well. So I think in our legal education here at Yธรรมศาสตร we are very well positioned. But if you then at some point move to the second edition, perhaps that is something that you may consider, whether somewhere there is something about corporate crime as well that you could include there. Right. So therefore, I would say overall, I think I can recommend this book to particularly not only our students, but also the students in the LBEL program at Jula. I think they will also be happy to read it, and maybe others who might be interested in Thai criminal law reading it in English. Thank you very much.
Thank you, Master, for your valuable insight. So last but not least, we are very delighted to have Professor Chan Wen Chong all the way from Singapore to join us today. So I'm probably going to give you a floor. Thank you.
Okay, thank you so much. I'm delighted to be here today to congratulate my friend Ronnakon on the publication of Thai criminal law. But first of all, please let me apologize for being late today. I actually have no excuse. I have been to Thammasat before and I've been to this conference room. So apologies. I will be on time the next time. Okay, so the previous speakers have talked about the book, and what I want to do is share a little bit about the person, Ronnakon. I first got to know Ronnakon when he was pursuing his PhD degree in NUS, where I was also teaching at that time. He was taking a course on comparative criminal law taught by Professor Stanley Yeoh. Stanley, Ronnakon, and I went on to do a project on criminal law of Laos, together with a French scholar who was working in Vientiane. We studied the Lao Penal Code and compared it with the French, Thai, and Singapore laws. Our work will be published by LexisNexis in April next year. It is titled The Lao Penal Code, A Comparative Discourse, and it's published in both Lao and English. Another project that Ronnakon and I were involved in is a book on capital drug laws in Asia, where Ronnakon wrote the chapter on Thailand's new narcotics code. So this book will be published by Cambridge University Press in June next year. In both projects, Ronnakon has been a serious and conscientious scholar, always willing to explain and debate points of law and assessing how Thai law is similar or not with other legal systems. One incident which I hope Ronnakon will not mind me sharing is that during the Capital Drug Laws in Asia project, after listening to the presentations by the other authors, he decided that he wanted to redo his chapter. So if I remember his words exactly, he said, "This is rubbish. I'm going to rewrite my chapter." So this episode, I think, shows that Ronnakon is always willing to listen, to revise, to improve on his work. And I think what we like most about him, willing to speak his mind. So I know that there were lots of comments today about the improvements that are possible in the book, and I'm sure judging by all his notes that he's been taking, that we'll see a lot of these revisions in the future editions. I have not read this current book, but I've seen the previous draft, and I think also from what Ronnakon has shown in the other two projects, I can definitely say that this book, Thai Criminal Law, will be a comprehensive and well-thought critique of the Thai criminal justice system. So my heartiest congratulations to Ronnakon on the publication of this book. And I believe, correct me if I'm wrong, it's a first book on Thai criminal law by a Thai scholar in English. So I thank him for making accessible Thai criminal law to non-Thai speakers, comparative legal scholars, but even Thais, I think, because they will benefit from his analysis and his critique about the criminal law in Thailand. A true test of a reference work is the citations by lawyers, judges, and academics in the future. And I have no doubt that this will happen many, many times in the future. Finally, as we all know, I think writing a book can be a very lonely and very demanding job. And I think Ronnakon has already thanked the people who are important to him, but I think they should be thanked again. So let's put our hands together and thank Ampaga, who is behind us. Thank you so much for supporting Ronnakon. Thank you.
Okay, thank you very much, Professor Chan. I don't think we have anything coming up on our online comment. So do our honorable guest today would like to share something more about this book? No? The dean say no. All right. So so on behalf of the all right. So please, Senator Gon.
I truly thankful for every comment. paragraphing number that what I get from working in Chan Wing Chong when we do the Lao Law project. The first draft did not include the paragraph number. That what I learned. That is very useful way to write a book, and that is the way I will use in the future as well. Talking to Kun Surasawadi, I cannot thank you enough for actually reading the book, and you spot. I don't want to use the weakness of my book. You actually, I will let you on a secret. Chapter 3 is something I wrote when I almost at the finishing line. So you spotted that it may be the weakest chapter among the 16 chapters. But just me clarify, even though I'm so not tired, but I'm doing my best every chapters, even though the deadlines were there. So, but the only reason I think I did not include many Supreme Court decision that I should have done is because we don't really have Supreme Court decision on the issue. But I should mention that we should talk more about that. Act requirement is very important. But among some scholar or even some books, just write some plain comments about Act requirement, and the Supreme Court did not take it seriously as in other chapters. So I should have done a better job on that and clarify things. And Pinay as well, Dr. Lasser, I will make sure that my book will be up to date if the next version is available, right? And I will include other, as Dr. Kanapon suggests that I will include some other offenses that are also important to Thai lawyers as well. Thank you so much for your comments, and it means a lot to me. As Chan Wing Chong say, I used to say, actually, it's not rubbish, it's I use another term. It's start with the C word, but yeah, this mean the same thing, right? So yeah, I will. I trashed it once, and I wrote a new book, and I promise you that if second edition is available, it will be a better book than it is today. But I hope this book does a fine job in explaining Thai criminal law for those, at least for those who are interested in Thai criminal law. Thank you so much.
ค่ะ thank you อาจารย์รณกรค่ะ So on behalf of Faculty of Law, Thammasat University, I would like to express our sincere gratitude to our honorable guest today, and as well as our audience for attending our book launch of Thai criminal law. Again, before we conclude, so this book, Thai criminal law by Assistant Professor Ranakorn Bunmi, published by LexisNexis and available both in hard copy and ebook format. So please check it out. Okay, so yes, so thank you everybody, and yeah.
If you are abroad, you may like to order it through LexisNexis website, right? But if you are in Thailand and if you like to get a hard copy of the book, you can do it at any Win Yuchon branch, including at Thammasat University at Rangsit and Thabachan campuses as well. It would be the same price. I will not get anything from the book, so it would be the same price as you buy it online from LexisNexis directly, or you bought it at Win Yuchon bookstores. Yes.
So lastly, thank you everyone for attending our book launch today, and you know now how to get it, right? Okay, so thank you very much and goodbye.